Good morning. Um, we're going to go ahead and get started with the seminar if everybody's ready. And so I'm Patricia Miramon, and I'm a parishioner here. I have been from Shreveport. Been in Shreveport since I was 3 years old. My husband, Paul, and I have been parishioners at St. John's for many years. We got married at Holy Trinity. So we've been around in this diocese for a number of years. The picture right there is myself and my daughter, Julia, who is also a lawyer. And Julia is also a CPA. She always said she didn't want to be a lawyer. She wanted to be she wanted to do something with math, and so she becomes a CPA. And then after becoming a CPA, she decided she didn't like tax and she didn't like audit. So she ended up going to law school, which has been great because I get to see her every day. Okay, so graduated from Byrd High School. I've been a practicing lawyer since 1985, so this is my 40th year. And that's just a little stuff about me. Okay, so when I started practicing, I didn't know any lawyers. My family didn't use lawyers. We really didn't know much about lawyers. And I graduated from college with a very useful degree of English literature. I really wanted to be a librarian, but then when I found out that the card catalog was no longer in use, that was a big blow. So the joke is, if you have an English literature degree, you've got two career paths. One is a barista, work in a coffee shop, or the other one is go to law school, so I picked the second one. So we have offices in Shreveport and also a small office in Benton. One of the things we do differently, and this is just because I didn't know any better when I started practicing, is almost all of our fees are flat fees, meaning that we tell you how much it's going to be. We have a fee agreement. The fee is what it is. So we don't charge for postage. We don't charge for if you call and have a change to your documents. We don't charge for any of those kind of things. So I call it, we don't nickel and dime you, right? And when I first started practicing, as I said, I didn't know any better, but I kept saying, why don't lawyers tell people how much things cost? I didn't understand that. I said, you mean you don't tell someone how much it's going to cost? I mean, how can they decide if they want to go forward? So I started doing that from the very first year of my practice, and really, honestly, that it's been such a gift because, I mean, I know I want to know how much something is before I commit myself, and I feel like people want that, and a lot of people do come to us for that reason. So over the years, when I first started practicing, I did everything. I did criminal, I did divorces, I did all kinds of stuff because, frankly, I was hungry. I needed to get some people in the door and get some money. Okay, so over the years, I started dropping things as I got more involved in the estate planning and probate and succession world. And trying to think what year, probably about my 30th year, about my 10th year of practice, I met Colonel Steve DePazler, who was then the head of the retiree office at Barksdale Air Force Base. And anybody who has a military background or knows a colonel in any armed forces, you know how they are. And so he called me and said, "This is Colonel Steve DePazler. I'll be at your office in 5 minutes." I had no idea who he was. And he came, and I called my mother, who was living at the time. I said, "Who is this?" My mother said, "Oh, he runs Barksdale." And so anyway, we talked, and he said, I heard that you will tell people how much things cost in the beginning. I said, yes. And so he said, well, I would like to work with you, but I'm going to tell you something. If you ever take advantage of any of my people, you will hear from me. And so we had a long and great friendship, and he passed away at the age of 101. But as a result of that, I got to meet and work with so many retirees in this area, and this side of the practice just kept growing. Okay, so now what we do is probate and succession. Probate and succession kind of mean the same thing. Probate just means you have a will, okay? So, and we also do a lot of special needs planning. So special needs planning is when you have someone who is disabled. So we do a lot of work with people who have loved ones at Holy Angels and other facilities. We do a lot of work with our friends at Families Helping Families. So we do a lot of that type of work. And so when you have someone, and we'll go into this a little bit more, but so that has become a big part of our practice. And then, of course, always the estate planning, which can be as simple as a will that's two paragraphs or way more complicated. We also do trusts. We also do powers of attorney. And we also do limited liability companies or LLCs. Okay, so this is us, and there's actually, we have another lawyer who just started here recently, and she is working with us as we continue to grow. She's also my next door neighbor, and so I've told her, I said, I'm going to try to have blinders on when I pull in my driveway and I see you over there. I'm not going to ask you anything. But so we're continuing to grow, and we have our office. If you've been over down East Kings Highway, where Ladies in Waiting used to be, that's our new office, and that's where we moved back in October. Okay, and then I also have a companion company, and it's called Laniap Fiduciary Services. And the reason we have this company is that when we were doing a lot of trust planning, and especially planning for special needs people, I was having a lot of trouble finding anyone who would act in the trustee role. And so, because a lot of the big companies were charging, they wanted a trust that had to be $1 million or more. Banks didn't want them. And so in 2017, I formed this company, and so we can act in those roles. Okay, so the reason I'm touching on this is that I have found over the years that there are people who say, well, I know I need to do something, but I don't have anybody. I don't have anybody that I can trust to be my executor. I don't have anybody I trust to be my power of attorney. I don't have anybody I can trust to handle things for me when I'm gone, and my special needs person or my spouse or someone I'm trying to take care of, I have no one I can trust. And so I started this company in 2017, and we now have roughly 200 cases that we manage right now. And luckily, I was able to convince my son-in-law to come be the manager of the company back in January as it continues to grow. Okay, so here's what you're here for. People always say, I don't know if I need a will. How do I know if I need a will? Well, the question is, what happens if you don't have one, right? So without a will, community property, which is what spouses acquire during marriage, everyone thinks, I have had so many people say this, I know my spouse gets everything when I die. And I say, well, do you have kids? Yes. Well, then that's not true, okay? So community property, you own half, your spouse owns half, and that half goes to your children, not to your spouse, unless you write a will, okay? So the children get it, the surviving spouse gets what we call usufruct or right to use. Usufruct has limitations So y'all, some of you may be familiar. Usufruct used to be so popular back 40 years ago, and now we're moving away from it because it has limitations and it has sometimes negative consequences. Okay, and I'll touch on usufruct again. Separate property, that's something that either you inherited or you acquired with your separate funds or you got it before you got married. That goes to the children directly. No usufruct. Spouse does not have right to use that. And so what's happened, excuse me. What we see happening a lot is since 2008, when we started seeing a lot of shale and oil and gas interests that people have inherited, and someone dies, and the spouse thinks they're going to keep getting that income. They're not. It goes to the kids. No usufruct, okay? All right, so forced heirship. Louisiana does still have forced heirship. Forced heirship says if you have a child who is under 24, the wording is strange. It says has not yet attained the age of 24. So if you have a child who's under 24, or if you have a disabled person of any age, then you have a forced heir. And a forced heir means that no matter what you do or what you say in your will, or if you don't have one, no matter what you say in your will, that forced heir has to be recognized as owning a portion of your estate. Okay? So, and there are people, lots of people, who have disabled children who are adults. Okay, so this is, so in calculating the forced portion is a quarter of the deceased parent's estate. Okay, so you can see that would add up, right? So you want to, if you have that situation, then you want to do something to make arrangements for the forced heir. Okay. We also have a thing in Louisiana called representation, and representation means that if your child died and that child had children, your grandchildren, those grandchildren without a will step into the shoes or have the same standing of your child, okay? So if you pass away without a will and you've got two children and then one passed away, and those grandchildren will come in for a share of the estate. Okay. Because of the fact we have forced heirship, that means the disabled person gets a share of your estate. And if that disabled person is on Medicaid and they inherit more than $2,000, they will be taken off the program. Okay? So very, very important to make arrangements for the person who is receiving Medicaid. And there are other government assistance programs that also have income and asset limits. So if you've got somebody that is disabled, who's an adult on Medicaid, we need to know, okay? We need to handle that and handle it by setting up what's called a special needs trust. A special needs trust allows the disabled person to be the beneficiary of the asset to receive benefits, but it does not count to remove their eligibility. Okay, so now we see how important it is to have a will, okay? This is always an interesting thing to me. The basic thing is that if you're going to go online and Google a will, it's probably not going to be valid for Louisiana. Years ago, I think it was Office Depot, used to sell some sort of will-making kit. And on the back of it, it clearly said, not valid in Louisiana. And you wouldn't believe how many people I saw that used it, okay? And I think it was $160. And I said, well, you know what? You could probably have just had a will made by a lawyer, and you would have known it was right, okay? Louisiana has very, very specific rules. You have to have a notary, you have to have 2 witnesses, and those witnesses cannot be family members. They cannot be married to your children. A lot of people don't know that. Be like, oh, my son-in-law can sign as a witness. That invalidates the will. Okay, I mentioned this about the Special Needs Trust, and I think if you've got that situation, that's a more in-depth conversation that needs to happen, okay? But basically, the bottom line is you need to have some kind of trust for the person who's on benefits. Okay, with a special needs trust, you also have to be careful. We see a lot of bad trusts, okay? If you're getting one off the internet or you're using one that somebody gave you that they used in their state, which is not Louisiana, let me take a look at it, or let us take a look at it. I'll look at it and I'll tell you it's good or bad, all right? And, but you want to make sure that you're absolutely following the rules. If the rules are not followed and the document is not written correctly, it won't work, okay? Okay, so sometimes we have people who, let's say their parent didn't plan, or they inherited something, or they were in an accident, and then they became disabled. So sometimes we have people who have already received money or assets, and they're trying to get on benefits or maintain their eligibility. They have to do what's called a first-party special needs trust, and that means that there's a certain kind of type of trust that's set up, and the trust receives those funds and allows them to remain on benefits. Now, here's the problem with that. If you don't do anything and your special needs person inherits from you when you die, they have to set up a first-party trust instead of the other one I talked about, the third party. The first party one requires that when that special needs person dies, whatever's left in that trust goes back to Medicaid, okay? So it doesn't get to be passed on to other family members. Whereas if we did planning in the beginning, we could have had, okay, the special needs person uses it for their lifetime, and then it goes on to other family members. Okay, and these are specific things about what trust can and can't pay for, okay? So I'm gonna skip over that. And then this has to do with choosing a trustee. So when you're trying to decide who's going to be in charge, whether it's a special needs trust or another type of trust, you need to make sure that the person or the company that you're choosing has accountability, has a bond, and so that you can make sure that there's not going to be any type of misuse of funds. Because if you name someone as a trustee, they have complete control over the asset. If it's a bank account, they can take it out. Nobody's watching, okay? An interdiction is when someone is disabled to the point that they cannot make their own decisions, and the court has to appoint someone to be their legal guardian. So this is an expensive process. It costs about $4,500 to do this process, whereas if you, let me get over here. This is what happens a lot. We get a call and somebody says, I came in town to visit mom or dad. They cannot take care of themselves. I'm having to move them to a facility. They're in the last stages of dementia. They're not able to sign any documents, but I can't access their bank account and I can't sell their house because they never gave me power of attorney. So if you have not given anybody a power of attorney and that happens to you, the interdiction process is the only thing we can do. So I say a power of attorney is kind of like, to me, kind of like an insurance policy. It's very inexpensive, usually runs about $200. So if you have a power of attorney, you can avoid this whole thing. You can avoid the court proceeding, you can avoid spending the money, and a lot of stress. Okay, so this is what we want to avoid, right? Everybody wants to avoid this kind of deal where everybody's arguing. So if you want to avoid that, the way to avoid it is to have a will, have a power of attorney, have a living will, which is sometimes they're called healthcare directive. You may or may not need a trust, okay? And if you have them and they're old, you need to get them out and read them. Okay, so powers of attorney most of them you see are for financial or health care. You can combine it the same thing. But you need one for all financial decisions, and you need one for health care. So people would say to me, I don't really need one for health care because my doctor's office knows my husband, and they know that he can make my decisions. It's like, well, what about when you get to the hospital and someone has to sign for you to have surgery, or you need to get records? Y'all have all probably signed those releases at the doctor's office for HIPAA releases. You do not automatically have the right to make healthcare decisions for your spouse or your adult child. So you need to have a healthcare power of attorney and a financial one. We do a lot of powers of attorney around this time of year when kids go off to college. Mom or dad calls and says, I just found out they won't give me any information about my child who's at LSU because they're 18. I said, that's right. So let's do a power of attorney so you have that power, okay? So a living will. Again, you get these off the internet, but Louisiana only has one form. Louisiana's form is one page, and we can't change it, okay? So if you got one from Texas that's 19 wishes, if you got one from somewhere else that's a book, that's fine. I mean, that tells your family what you want, but you still need the Louisiana document, okay? It just says who's going to make your decisions about termination of life support if you cannot make that. And it also says the only decision you can make in Louisiana is whether or not you want food and water through your veins, okay? Or a tube. And that was in response to, y'all remember the lady, the Chavot lady that was in the coma? Louisiana's form was changed right after that in 2004. And so that's the only thing we can do. And I cannot change the form. Okay, besides having somebody's special needs, why else would you need a trust? So we get calls all the time. People say I watched Susie Orman, and she told me that I need to put all my assets in a trust. Well, you really don't need to do that in Louisiana because what does Louisiana not have? Louisiana does not have inheritance tax. It's zero. Louisiana does not have any state inheritance tax. So when you have a state with no inheritance tax, you really don't need to worry about putting things in a trust to save inheritance taxes, okay? You can also use trusts. Trusts are great for grandchildren, children. Maybe you've got somebody who isn't disabled, but they're not that great at spending money, or they don't know how to save, okay? So this is what I was talking about. We have no inheritance tax in Louisiana. So then the question is, well, I've been reading about this, and I've been told that you can be tied up in the probate process for 5 years, and it can cost you $40,000 and all kinds of stuff. Well, Louisiana has, again, what's called non-administered probate. So Louisiana's process takes about 8 to 12 weeks, and it usually runs about $3,500. Comparing that to setting up a living trust that then you have to donate all your property to, and then that can cause all kinds of title problems down the road, and you're going to be spending a whole lot more money setting this up than you would just having a regular will, okay? Okay. So when somebody passes away, the process is we do what's called the probate, which just means we have the judge formally recognize the will as the final will. We have the executor appointed. There's two main steps. Step one is that step. Step two is we close it out and we name the heirs, okay? Okay, if we don't have a will, we still typically have to appoint an administrator. So that's also a succession process, but that's how we go through step one. We appoint an administrator. Okay, if there's debts, so between step one and step two, if there's debts, or there are things like a house needs to be sold or something like that, then there'll be a period of what we call administration. Okay? All right. Some things do not pass by will. If you have life insurance, that goes to the named beneficiary. If you have an IRA, annuity of any kind, goes to the named beneficiary. Retirement accounts go to the named beneficiary, okay? A CD that has a name on it, a pay-on-death CD, goes to a named beneficiary. So when you're thinking about your will, you want to also look at your documents and make sure that all of those beneficiaries are right, okay? We have had many situations in which someone was a beneficiary on a policy, and maybe they were estranged, or maybe there was a divorce in the family, and the thing is, the beneficiary is the beneficiary. There's nothing anybody can do. Okay, so again, Louisiana has no inheritance tax. Federal tax, which does apply to all residents, all people in the United States, that it says 11, but it's a little bit bigger right now. That means if your estate is over $12 million, there will still have to be a federal return filed, okay? And people say, oh, wish I had that problem, right? But I'm gonna tell you, the people that have that problem are not all that happy because federal estate tax is in excess of 40%, okay? So what I put in your packet are, it's just general information and forms. So if you call our office, let's just say you decide, hey, you know, I heard Patricia speak and I wanna go ahead and get something going. What'll happen, just stepwise, is you'll contact our office. You can either do it by phone or you can go to our website, which is on all the documents, and you put in your inquiry, okay? So you can put in the inquiry, and then it's gonna generate the inquiry back to our staff, and then our staff will contact you to set up the consultation, okay? And we can do them in Shreveport, we can do them in Bossier, we can do them by phone, we can do them by Zoom, whatever way, okay? So, and then once we're finished with the consultation, if it's something that we think you should go forward with and we make a suggestion to you, we generate a fee agreement. The fee agreement is then signed by both of us, and you pay half. So you pay half, and then you pay the balance when the paperwork's ready, okay? And if you decide not to go forward, then you just owe the consultation fee, okay? If you, the consultation fee is applied to the fee to reduce the amount, okay? In the packet is our contact information, and also my card should be in there in the very front. That is my direct email address. So if you want to just, you don't want to go through going through the inquiry online, and you don't want to call the office, but you just want to say, hey, this is my situation, you know, what do you think? Or I'm not going to give you a full consultation by email, but I'll reply back, what I think you should do or what the next steps, okay? So you can email me directly if you don't want to go through the whole thing, okay? I guess the best thing I can say at this point is, and I know a lot of you have already done this, and I want to commend anybody that has done their estate planning stuff. I'm a member of an organization, a national organization, and they always do a survey to see how many people don't have any estate planning documents. And the number's something like only 40% of people over 50 have any sort of document, anything, whether it's a power of attorney, a living will, or a will. So I want to encourage you to get it done. It's not the most fun thing. You'd probably rather spend your money and time doing something else, but it's important. And also, you can put in your will charitable bequests. So if you want to make a donation to a charity, you can put that in your will as well. I think the hardest thing, the saddest thing is when someone comes in and the person has died or they are not able to make any decisions and they have nothing. They have no documents and everything's a mess. That's really sad because it can be taken care of relatively simply and relatively cheaply. Okay? And when I say that, I always tell people I'm guilty of it too, procrastination, all right? I do this kind of work all day, every day. And a couple of years ago, my husband and I were driving to North Carolina to take some furniture to our daughter. And you know how you do before you're going out of town? Say, I need to probably pull that stuff out. And look at it real quick. I pulled it out. I had not made changes to it since my son, who's now 26 years old, was 2. Okay? 24 years passed before I took the time to look at my own thing. Okay? I'm trying to be better now. And I have my daughter on my back now like this. Did you do that? Did you do that? Did you do that? But again, whether it's your New Year's resolution, your fourth quarter 2025 resolution, let's just get it done, okay? I find that most people want to do it. They don't know where to start, or they feel like it's going to be too expensive, too time-consuming. And, but, the first step is all we need to do, okay? I have some more time if y'all want me to answer questions, or we can just stop and you can talk individually.
I do have a question.
Yes, ma'am.
Okay, what about if person cannot afford to have a will written by attorney? Can you write your own will?
You could write your own will, yes. However, people mess them up, okay? Because the handwritten will has specific things that have to be in it. Number one, it has to be 100% in your handwriting. It has to be entirely written in your own handwriting and dated on every page. Well, you could have a space, but what happens is that people invariably do something like get it notarized, okay? Or get their neighbor to witness, or type it on the computer and fill in blanks, or not name an executor, or not waive the executor's bond, or not, they'll say something like, I leave my house to my son, and I leave my car to my daughter. That's it. What else? Okay, so there's nothing, there's nobody, they've then done a hybrid. They sort of did a will, but there's a lot of stuff that was left off. A simple will is $200, okay? Hopefully, you can come in and pay the $100 down and the other $100, okay? We do have people, I've had people who say, look, I got to get this done. I can only pay you $25 a week. I have several people who have done that, and that's fine. I want you to have it done, okay? And I would love for you to have it done with our office, but if you're not going to do it with my office, do it with somebody, okay?
Understanding
Yeah, well, that's what a will. So our typical and yeah, so we have a fee sheet that might not be in that packet. If it's not in that packet, it's on it's on our website, and our fee sheet has everything listed on there. Has how much everything is. It has basically people are divided. You kind of fit into one of three categories typically. One is our basic stuff, which is your will, your power of attorney, your living will. 2, you add the trust on. 3 is more complicated. But all of our fees are published. They're on our website. If you don't see them or you want to email me or call the office, I'll send it to you. Okay? And then you can decide. All right? The other thing is, let's say you come in and you don't like my price. You don't have to go forward. Okay? I don't know what everybody charges, but I have been told that we are on the low side or more reasonable. Luckily, we have a huge practice. Last year, we took in over 860 files, and that's just with our small staff. Last week, my daughter was telling me, because my daughter's an accountant and she's always looking at numbers, and telling me how many people came in, how many people went forward, how much money we made, how much money's in the bank, and I don't want to know. I'm just like, okay. We took in 25 last week, so we're taking in about 100 cases a month, but we do it all the time, every day, and everybody in our office knows what to do. So we can do it fast, and we can do it a lot more cheaply. Okay? Yes.
If you're married with no children and you pass away, does your spouse automatically get all of it unless it's written in the will?
Your spouse gets all the community property. Okay? So if you had something like you owned before you got married, or you inherited some oil and gas or something, that goes to your siblings. Yeah, a lot of people don't know that. And that's a shocker too. So people say, he hadn't even talked to his sister in 10 years. I'm like, well, we probably should have done something about that, right? So again, if you're gonna say, I'm not gonna do a will, I mean, nobody's gonna make you do one, right? If you say, I'm not gonna do it, well, then you just need to know what the consequences are. And if you accept the consequences, it's okay, right? But it's typically a lot more expensive and time-consuming when I don't at least have an executor appointed. Because if I don't, we have to appoint an administrator, get a court to approve that, have the person post a bond, file a list of assets, all this kind of stuff that you could avoid if you just had even the basic document.
Will the power of attorney be included in that, in the will, or the separate?
A power of attorney is a separate document. That runs you about $200. Yeah. All our fees are on there, published.
Say, for example, like, you have a bank account that is like both you and your husband.
Mhm.
So the husband dies, or which one? Would any of the children be able to, like, sign the check for, like, say, funeral arrangement and all that, or?
Okay. So one of the spouses is still living that's on the bank account? Okay, so this is also a little bit confusing. Banking law has its own rules, all right? Meaning that if you're on an account, and it doesn't matter if you're husband and wife or it's you and your daughter, if somebody's on the account with you, if that person goes to the bank, they have the right to take the money out, okay? If you die and that person's still on the account, they still have the right to take the money. However, just because you're on a bank account with someone does not make it your money. Okay, so if I put my daughter on my bank account and I die and she's never put any money into it, she's considered to have been on there as a matter of convenience, and it forms part of my estate that goes to my heirs, okay, under my will or without a will. Somebody had a question.
You said the executor.
Mm-hmm.
What if I read state versus
Yeah, she's asking, does your executor have to be from Louisiana? Your executor can be from anywhere. Your executor can be from anywhere. If your executor is out of state, they have to sign a paper that they appoint an in-state resident, which is, we do it all the time. So they just appoint our office. It's a very simple one-page thing. It's no big deal. We have executors not just all over the United States. We have them all over the world. I have people everywhere. You do not have to be in Louisiana or even in the United States. Okay? Okay. All right. Well, I hope y'all enjoyed it. And oh, I'm sorry, one more.
We went to a seminar, if you can call it that, just like this about 5 years ago, when we had been told about the trusts and how great they were for various reasons, instead of a will is what we were led to believe. And one of the primary things they were talking about is when you become elderly and you need to go in a nursing home, then they put you in a nursing home. If you don't have a trust, the nursing home can take some of your estate to pay it off and all that.
Okay, he's asking about going to a trust seminar. I hope you got a good meal. Did you get a steak dinner or anything? Yeah, yeah, okay. I tell my clients, they say, hey, what do you think about me going to that? I said, why don't you go and eat dinner? I would go too, right? Just don't sign anything, okay? All right, so what you're saying is that the seminar he went to was someone put it on and said how everybody needed to have a trust. Okay, they are salespeople, okay? So they are salespeople. They're trying to sell you to buy a trust. In the paperwork and in the slideshow, what happens is if you create what they're talking about is a living trust, okay? And they say a living trust is going to be all these great things. It's going to avoid probate. Well, in order to make that work, you have to donate all your property to it, okay? And when you do that, you lose your homestead exemption, okay? You also, unless it's an irrevocable trust, it doesn't have any effect on your ability to apply for Medicaid for nursing home coverage. Okay, so if you have a living trust, and this is what happens. These companies have been investigated many times, but if you have a living trust, you're the trustee and you're the beneficiary. What does that do? You're still in control, right? So as far as any agency is concerned, you've done nothing. You're still in control. You can still do whatever you want to with assets, right? So how did that really do anything? As far as any government agency is concerned, a living trust does zero, okay? Now, there are Medicaid trusts, and there are people who specialize in Medicaid planning. And the purpose of Medicaid planning is to try to get your assets below $2,000 so that you can qualify, okay? But what are you doing? You're trying to qualify for a Medicaid facility, okay? Not assisted living, not the top of the line, okay? Whichever Medicaid facility has a bed, you can have a roommate, okay? So, and then the assets that you've transferred to that trust, let's say you put your house in it. So you've lost your homestead exemption, and now you got your trust in it, your house in it, and you lived 20 years after you put your house in there. So your house increased in value, right? And then you die, and your heirs have to take the value of the house as it was when it went in the trust. Why does that matter? Because they sell it, they have to pay capital gains taxes on all the accrued value. So anybody, I just say this in general, and this applies to me too, but anybody who says everybody in this room needs X, and here's the form, and all I have to do is change the names, it's not true. Okay, everybody's situation is different. But keep going to the seminars and getting the free food, okay? No harm in that. But just make sure that you know what you're getting yourself into. Yeah.
This will, when you make a will in Louisiana, suppose you move to another state, is it still good, or do you have to have another will because now you live
Okay, so every state in the United States has what's called full faith and credit. That is in our Constitution. It says that if you make a document that is valid in one state, it is valid wherever you go. Okay, so if I make a will in Texas and I move to Louisiana, it's still valid, vice versa. However, if I do say this now, let's say that you are in Louisiana and you decide you're going to move somewhere and you're never coming back. You might want to at least make an appointment with a lawyer and say, look, this is what I've got. Do I need to tweak anything? Because the documents are valid, but there may be different procedure rules, okay? But we probate wills from all over the place. Yeah, as long as it's valid where it was made, it's valid here, and vice versa, anywhere. Okay? Yes,
Small question. You said when you're in the account with somebody else in a bank account, like you have no right to that money, like can you make decisions, like if the person dies and you're in the same account with that person, can you make any decisions with that bank account?
okay, so this is another bank account question. So you're on an account. So let's say you're on an account with your mom, all right? And if you got on that account by taking your power of attorney in there, or the bank puts you on as an agent, then when she dies, you no longer have access. But if you were put on the account as a joint account holder, you continue to have access. Okay. Well, I mean, she's asking, would she then be able to make whatever decision she wanted to with the money? As far as the bank is concerned, yes. Okay. But we have situations all the time where someone puts a child on a bank account and then they die, and that person's like, oh, well, that's mine because mom put me on there. Well, not so fast, okay? Because mom didn't have a will. So that means that money is mom's money, and it's divided among all the heirs, not just the person on the account, okay? So again, if everybody would just have a simple will. Just get us a will. That's all we want, just one will, okay? And then you can do it and you can forget about it. And people tell me all the time, gosh, I feel so much better. I got this done. Got it done. So, okay, I hope to see some of you and talk to you. And thank you.
Thank you, Patricia. Really some really good information for all of us to take to heart. And on behalf of